Hi, everyone. Welcome to week 7, chapter 6, where we are finishing up our textbook. We're going to be talking about prisons, jails, and community corrections. Obviously, something we're going to be talking about is incarceration. So that's kind of a big focus. I'm going to try and do this lecture with Textbox to see how that works. The online format, things are always changing, so I'm trying something new. Not new, rather slightly different. So, anyway, just to kind of emphasize, we are talking about the last chapter of our book, section 6. So, just want to real quick throw out, why is it always these three: Texas, California, and Florida? If you get that meme and joke, you'll know what I'm talking about. But anyway, diving in to this week's lecture. So, incarceration, we've talked about this before. This is this kind of concept of, instead of corporal punishment, so instead of bodily punishment, this is, a variation of that. It's not punishment as in pain, but punishment as in fines and things like, and particular incarceration, imprisonment. So incarceration is actually relatively new, historically speaking, because most of history has been corporal punishment, and that means that there's some kind of physical toil, physical pain. This is, if you want to get religious, this is crucifixion, this is hanging, this is, if you want to go myth of Sisyphus, you push a boulder up a hill and then it falls back down at the end of the day and you have to do it all over again. The idea is that you pay for your crime through some kind of physical labor. And so, to a point, that is something that's returned to our system, but incarceration itself is different. And we really kind of get this in the 18th century Quakers. For those of you that aren't familiar, the 18th century Quakers were very puritanical, and by that I mean like very traditional. If you think about the Puritans and things like that, those tend to be the Quakers. Think about the Quaker oatmeal man. We're talking the Pilgrims with the special buckled shoes and everything. But the 18th century Quakers, they kind of came up with this modern prison model, this incarceration over corporal punishment, and their idea was religiously based. So that's another important thing, is that Quakers are religious inherently. So their idea was that you rehabilitate a criminal through hard labor, religious study, and penitence. And if you're familiar with Indiana Jones and the Last Crusade, the first trial of the Grail is only the penitent man will pass. Penitent and penitence is this kind of spiritual, pious is not the right word. It's respectful, it's reflective, it's this kind of thing. And so the Quakers decided that instead of, let's put the criminal in the stocks and make fun of them, their idea was, no, let's force them to do hard labor, sit in isolation and reflect upon God. So this kind of try to make it more religious and more reformative. And so that's where that idea of rehabilitative kind of structure to punishment, and I put that in air quotes, comes from. Nowadays, obviously, it's not religious. It's the idea is for deterrence, retribution, and incapacitation. And so these are things that we've talked about before, but, deterrence, we're trying to deter individuals from committing a crime, retribution, trying to get what is due for a crime. This is the eye for an eye thing. And incapacitation, holding an individual from causing more problems to society. And so this is what we're talking about. And so one thing that our book does kind of talk about, I just want to put out there, is the prison industrial complex. The modern view of how our prison system works is a growth industry. Elected officials want to be seen as tough on crime, and this has actually led to the overpopulation problem in prisons. and financial burden of building new prisons. Now, do not get me wrong. The hard on crimes has led to the systemic racism of, fining and imprisoning more and more people of color who commit drug crimes. So marijuana charges in the, last 30, 40 years. These are because we wanted to be, quote, hard on crime. And so instead of being understanding and rehabilitative, we're just trying to incarcerate people. So that is an issue. And so when we talk about overpopulation, while yes, there is a disproportionate color difference. So colored individuals are the ones that have a higher percentage. The overpopulation problem is not just racism, it is the inherent political nature of the criminal justice system and the way politics works its way into it and forces more officers to incarcerate and laws to be passed that make things illegal, that force individuals to be arrested. Quick apologies just in general. I still have that cold from the previous week, so I will still cough and might have to take a quick break here and there to take a drink of water. I just want to let you know before I dive fully into this. All right, so the focus of, like I said, our thing today is to talk about really incarceration and then the alternative to incarceration, which is parole/probation. And we will talk about that. So we're going to start first with just talking about jails in general. And so much like our concept of the sheriff and things like this, lo and behold, our roots are once again in feudal medieval England with gaols. In particular, I'm going to write it out. Our author puts it out there, but GAOLS. This is the, wonderful oldie English. Not necessarily Old English because that's a separate language, but not relevant for this class. But this idea of a gaol or a jail is where an accused individual in the area was to be held before their trial. So it wasn't you were in jail after a crime. You were in jail awaiting your sentencing. So before the sheriff or magistrate or judge or whoever would say, yes, you are guilty or no, you are not. So this is where you were held, which is to this day still one of the roles of a jail is to hold individuals who are awaiting trial. So kind of cool that some things don't change, but a lot also changes. And so in the 1800s, this function from just holding the accused while they were waiting trial, this actually was extended to housing those convicted of minor offenses. So, none of the big crimes like murder, but the little things. But it's also where we would hold vagrants, which is people that, wanderers, they don't actually have a home, that kind of thing, or could cause trouble, and also the mentally ill. And we will talk about the mentally ill in a little bit in this chapter. So if you have any issue with discussion of how the mentally ill have been treated by the general public over the last, couple centuries, it does get a little difficult and offensive. This is the history, so I'm not saying it to offend anyone. I am simply giving you the history part of it. It is wrong, and we definitely need to continue to be better as we are now. So we're not great now, but we need to continue getting better when it comes to handling the mentally ill. And even the term I don't like, but it's hard to find a good term that works that's not too offensive. Anyway, so something that is important and we kind of need to think about is that jails are critical components of the local criminal justice systems. So while, yes, the federal level is important, jails aren't really at the federal level. They're federal prisons, but jails are really critical components of the local criminal justice systems. I said it twice. It's probably important and probably going to show up somewhere. Local law enforcement, state police, wildlife conservation officers, and federal authorities will use jails for local community issues. So if they're processing some kind of investigation in a particular area, they will use a jail as a local jail for those types of things. They can hold temporary incarceration. These are places where if they're awaiting a large trial or something, they will be held there. These are important to the local criminal justice system. Something that is important to note, though, is that even now, our jail system, not prison, jails, jails hold everyone. Men, women, children, adults, serious offenders, minor offenders, addicts, those suffering from mental illness, they hold it all. And so, with that in mind, you have to remember, we've talked about it several times before, the goal with the jail is temporary holding. It's not meant to be a long-term sentence. So it's usually less than a year. And so with that in mind, there are two major functions of a jail. And that is, and I'll write it here, two major functions. And that would be number one, intake, and number two, custody. Sorry, I was looking for my mouse, actually. Okay, so what do I mean by that? Intake is, as we've talked about in the breakdown and the structure of the criminal justice proceedings, like through the actual steps of how the system works. Intake is where we get all the demographic information. We find out who the potential offender is and all these other things. So part of this intake is assessing how much of a potential threat the individual is and the risk that they could pose to others. And so this is where we kind of decide, well, do they stay in a jail, or are they released, or are they need to be transferred to a more secured facility, or do they need special help, or whatever it may be. Intake is where we find out a lot of that information. And so that is one of the major functions of a jail. The second one is custody. And this is where the pretrial detention and or punishment for an individual who was only getting a jail sentence. Custody is exactly what it sounds like. It's holding and being responsible for the individual. You're to hold those awaiting trial for whether probation or parole violators. It's also awaiting an actual first trial, things like that. Those who are waiting trial, being in jail is not punishment. It's part of the agreement that they will attend. So, remember the concept of bail bonds. Bail is in lieu or in replacement of custody into jail. But with this custody, part of this is that the individual has to be kind of taken care of. And I'll talk about that here in a second. In regards to the punishment aspect of custody, incarceration deters offenders, or at least that's the goal or belief, that incarceration will deter offenders. Obviously, programs like the Scared Straight program didn't necessarily work, so incarceration doesn't necessarily deter offenders, but the data is too up in the air in regards to that to make a for sure statement. Now, in regards to punishment, there should be an offer for rehabilitation, but few jails actually have the programs designed for such. If you remember, jails tend to be small and at the community level, whereas prisons are at the state or federal level and have a lot of wide programs available to their incarcerated. So while rehab is a great option, a lot of jails don't necessarily have that simply because they don't have the funds, they don't have the staff, they don't have whatever it may be that they do require. And so, because of this kind of wide array of individuals and things and reasons and all this other stuff, when someone is in custody of jail, like a jail, the jail is responsible for the health and well-being of that individual. So, you can't treat them terribly and things like that. They still deserve some rights, and we'll talk about prisoners' rights here in a bit. But there's one thing at the end of section 6.1 that I wanted to look at in the text, but I didn't want to actually put in our notes, and that is this little thing about juvenile detention. And so we've talked about some of this stuff before as a little hint. And as I said, next week in our final week of class, we will talk a little bit more focused on juvenile justice kind of stuff. So there is a trend of lower numbers in big incarceration facilities and more at the local level, because we've seen, the scared straight concept doesn't really work. One of the things that is talked about here is this idea of security, that, locking youth in quote unquote sleeping rooms. So this idea that, you are at night locked in a room where you're supposed to sleep. There's arguments whether that is constitutional or not. But again, if we remember, because it's juvenile, there's some things that are illegal because of their age and some things that aren't. And it gets a real mess. So there are people on both sides of the argument that locking juveniles into sleeping quarters is right, and some that say it's wrong. But it's kind of one of those things where I don't necessarily know that there's a right answer. So the other thing with this is the most common type of facilities for juveniles are ones that consider themselves these particular terms, and that's important: residential treatment centers, as well as detention centers, these group home, training school, shelter, wilderness camp, and diagnostic center. All of these are juvenile detention type responses. These are the response to prison. It's these facilities that are almost more of the rehabilitative side, more like the probationary stuff, and we will talk a little bit more about it. But I at least wanted to throw out that, some of these words you might have seen before when interested in juvenile detention or even in regular prison. If you're a fan of terrible cop shows, you might have heard of group homes and things like that. Yeah, these are terms that they use. They're all similar in practice. The idea is that the environment is meant to be a more stable environment that teaches children responsibility. I say children, and that's not quite the right word, but they're trying to teach juvenile offenders how to be responsible for their own actions and things of that sort. All right. So I'm going to create another text box because I can. So now let's talk about prisons, because we did talk about jails, and now, again, remember, there is a difference. Jails, again, are the local, smaller level, tend to be run at local municipal levels. In some jurisdictions where they do not have enough staffing or anything for jail, they might actually work with others in their county area to kind of have a county jail. That's something from the text that I didn't talk about previously, but it is important to note. But with prisons, as I was getting to, prisons are these larger facilities that offer more options and things of that nature. And so because of that, there is a wide variety of facilities. But regardless of what type of facility, all inmates that are to be placed in a prison are assessed before placement to make sure that the best fit and treatment option is chosen. Because remember, these are places that are large enough that have mental health and things like that. So there are different ways to go about it. And so we will talk about the different classifications of prisons and how things kind of get decided to a point, not super deep, but we're going to talk a little bit about that. But before we can talk about that, we need to talk about a little bit of history of the prison system. And so one thing I wanted to start with is the modern concept, or rather, it's not what I want to say. So kind of the modern idea of prisons really starts with, and our author does state this, John Howard. And he advocated for penitentiaries. And I'm sure you've heard the term penitentiary before. This is not a new term. If you haven't seen it spelled out before, penitentiaries is the plural, or penitentiary. So a penitentiary is early prison system, and it, much like our Quaker Puritan brethren once believed, it also has roots in religious groups. And so the concept of the penitentiary was, it was a place for an offender to be penitent. And if you remember, I said I was going to come back to this. This is the idea that you are thoughtful and remorseful of your actions through a higher being. And this tends to be under the Christian sphere of God. Big G, little O-D. This is not a religion class. This is a criminal justice class. So it's important to just note, like, this is where it was rooted and based in. This is not a religious thing. This is just simply the history of it. And so the idea in a penitentiary is that you work and you reflect on your misdeeds in a solitary cell. And so all you do is you work real hard and you go to your tiny little cell and you think about what you've done and you hopefully decide that this is not the life for me, and you make a change. That's the point. That's a penitentiary. And so this kind of went one step further, and of course it has to be Pennsylvania. But Philadelphia's Walnut Street Jail ended up modeling this kind of penitentiary system and went one step further. It was referred to now as the Pennsylvania system. Not great for us. But the Pennsylvania system is where inmates were confined to small, dark cells and no communication whatsoever. So they didn't talk to anyone. Still, the idea of being penitent, repenting for your sins, feeling sorry for what you did, and trying to make it up through labor. But what made it worse was your cell was small and dark, so no light, and you weren't allowed to talk to anyone. And so some early critics definitely kind of suggested that there was harm being done to individuals, specifically severe distress and mental breakdowns. And I think anyone who has a modern understanding of this would agree that isolating someone and not allowing any kind of human interaction, that will severely affect an individual. So yeah, definitely not great. But at least we're not alone, because New York started in 1819 a congregate system. And this is similar to a penitentiary, but the idea is that inmates spent the night in individual cells, but they worked together in like workshops. So they did have human interaction. However, and this is the asterisk to it, they were not allowed to talk while on the job or at meals. So you could see people, you could feel people, but you were not allowed to talk. Not at all. So not really great, but those were kind of two of the prevalent major prison movements in this era of history, in American history, specifically in the Northeast. Now, at this time, we also had the South and we had some of the West being established as territories. The West kind of did whatever they wanted. Essentially, they took parts of this, but they didn't have the penitentiary system as we had it. And the South went with a different strategy, particularly the Deep South. So we're talking like Alabama, Virginia. Virginia is still too high, but Alabama, Carolina, that kind of area. They used the lease system, and a modern pseudo equivalent, something that helps make sense to someone, is it's like indentured servitude. This is the idea where a business would hire an individual who is incarcerated for labor. Obviously, they would return. They were not owned, but they were owned by the prison. But they would get housing through the prison, and they would work for this business. And so that was this idea that, you were essentially slave labor. So the South got rid of slaves as people who had rights and moved to slaves as in incarcerated individuals who, quote, not real, but quote, had no rights. So it's just important to note that. And then things did change, and this is one of the few dates I am going to write down in this lecture today. In 1870, there was a meeting of the National Prison Association. Which is now actually something different. It is the American Correctional Association? Yes. I want to make sure I was putting the right words. All right. So in 1870, the National Prison Association, now the American Correctional Association, excuse me, they issued a Declaration of Principles. And this was that kind of in a response to this penitentiary model and to the Deep South's lease system. This was saying prisons, the goal of a prison should be reformation, to reform an individual with the idea that their release is their reward. So they worked towards reforming themselves from a prison or from a criminal to a free citizen. That was the goal. And so that's when they said, even though they're incarcerated, they do have some rights. They're not slaves. They're not property. They should be seen as humans who made mistakes. And so this pushed through. The 1930s saw a more rehab model after this kind of talk and this declaration. So they kind of viewed criminal activity as a medical disorder. So you didn't just commit crime because you wanted to commit crime. There was an underlying medical reason, whether it was mental health or something of that sort. But in the 1970s, as we got hard on drugs, we also got hard on this. And so the pendulum switched to the other side, and we went, no. Crime is not a mental health issue. This is just a you are a bad person thing. And so whether you like it or not, that's the way the system has been, and we're still on that end more often than not. But you can definitely see more and more people viewing some things that we consider crimes as more of mental health issue. And so this really is the crime control model, the 1970s piece. This is where we are tough on crime because rehabilitation was quote unquote soft. It was not doing the right thing. It was not actually making a difference. the unfortunate side effect of this is that you had an increase in incarceration because, well, now you were being harder on certain crimes. Now you were considering other things to be imprisonable offenses. So now you had an increase in incarceration, which, going back to our idea of overpopulation, it's important. It's all connected. All right. And so with prisons, we kind of hinted at a little bit. And if you're familiar with the prison system, even if you didn't know the separation between jails and prisons, I'm sure you've heard that, there are different types of prisons. And this is really distinguished by the custody levels, how many prisoners they can hold and what kind of services and mobility they have. And by mobility, I mean able to move around within the system. I don't mean that how much they're allowed to move during the day. I mean, how can they move through the system? And so some of these terms should be very familiar to individuals. I don't know. I've heard of them before I was in criminal justice, so I hope that they're in the public sphere of knowledge. But we have super maximum, maximum security, medium security, and minimum security. These are the four major classification of prisons. There's also private prisons, which we'll talk about as well, which is a sub piece. But super maximum prisons, this should be pretty obvious. This is for the most violent and most likely to escape inmates. This is for the quote unquote worst of the worst. If you are a fan of Marvel books and movies, you'll be familiar with The Raft, which is essentially the same concept. It's the superhero Supermax prison. And so, yeah, super maximum security prison is top of the line, most strict. Inmates at super maximum security prisons do not have mobility, if any. If they have it, it's very minimum. But the idea is, these are the people that tend to lose most of their rights as a citizen for the most violent crimes. And the first and most famous prisons of these is Alcatraz, which was built in 1934. So if you've heard of Alcatraz, that is a super maximum prison, and it's been in operation since 1934. All right. The next level down is a maximum security prison, and this is for, the dangerous criminals. These are still the high-end, possible, potentially dangerous. Really one of the biggest distinguishing marks between a super maximum and a maximum is cost, really. Super maximum are going to be the most expensive ones to build and to staff. Maximum security tends to be the ones that are used more often. They're treated in a similar way as super maximum. Their security measures are still very high. We're talking, high walls, high fences, regular surveillance and security and walkthroughs and all that other stuff. But maximum security holds dangerous criminals. They have death row, which is a subsection within maximum security prisons. In jurisdictions where there is the death penalty, really those are just for individuals who are awaiting to be put to death for death row, as far as that's concerned. But in a maximum security, there is potential for a little mobility, but it's not much. So, like I said, it's important to note really the biggest difference between a super maximum and a maximum security prison is the price or the cost of building and maintaining, as well as some of the minor details of their security measures. But they're both at the high end. Next down is the medium security. These are still dangerous criminals, but they're less of a threat to individuals both within and around the area. There's still very tight security, but there's a decent amount of mobility for a prisoner. They can be transferred to other medium security facilities and things of that nature. There's potential for parole for these individuals, you tend not to have that option at the maximum or the super maximum level. Sorry, I hit the mic with my water. So if there was a loud bang, I'm so sorry. The lowest level is the minimum security. This is for the nonviolent offenders and those who are a very small escape risk. Really, this is like, I would argue, here in Erie City proper, the Erie County Prison, which is on Ash Street, I would definitely say ours is probably, and I don't know for sure, and I'd have to look it up. I'm sure ours is probably a medium security facility, but it's between that medium and that minimum security. It's not a maximum or a super maximum prison. I'll tell you that much. But minimum security are, I don't want to say low end because that makes it sound like it's not important or it's not good. That's not true. It's less of a fear and less of a constant work to make sure everything is running smoothly because it tends to be lesser offenders. And so the other goal with this, with minimum security, is it's meant to make the transition from prison to release into the community a lot easier. It's meant to be more gradual rather than, oh, you're done, you're ready to go, welcome back. It's meant to be kind of that stepping stone. And then, as I said, there's private prisons. These technically don't have the same classification, but they have the same classifications. Private prisons are really just private organizations claim that they can run the prison better than the government can. And so they fund it, they hire their own staff and all this other stuff. And yeah, they get a kickback from the government for those individuals who are sent to their facility and things like that. The private prison system is part of the reason why if you know anything about our history of PA, the Luzerne County prison scandal, the Cash for Kids thing, was sending juveniles to a private detention facility, and they were getting huge kickbacks. And one of the judges who was actually sentencing those kids was a part owner, so he was getting money for sending the kids. So he was it was a whole scandal. If you're interested, you can look up the Cash for Kids scandal for the Luzerne County, PA, which is in the eastern part of the state in the Philly coal area. Anyway, but private prisons, there tends to be that problem because it is a private institution. It's not the government run, but the government sends people there. Anyway, so when we think about prison population, there's another thing that comes up, but we need to address it slightly, and that's special populations. These tend to be, more often than not, the elderly, the ill, and the mentally ill. And so when we talk about the elderly, there's a different level of care for an elderly inmate as opposed to a 20-year-old inmate. There's a significant difference in how their bodies work and what kind of care they need. So these are things that are thought about. And so within a prison, especially one that has decent funding and things like that, they can offer programs for individuals so they can offer better health care for the elderly inmates and things of that nature. Obviously, the ill typically have some kind of medical facility on site, so that is kind of in that nature. And then the mentally ill, this is where I have to say the unfortunate reality is historically we did used to have mental asylums, which were places where we would lock up those who were deemed to have some kind of mental illness, and things like electroshock therapy and torture were used on those individuals. And while the positive side of we got rid of those because, well, we said that's not human rights, that's a problem, this led to a lot of individuals who would have been in a mental facility, an asylum, then put in prison because they were non-compliant and didn't follow the law. And so there is an issue, and it's still an issue to this day. There's still a severe issue of mentally ill individuals who are incarcerated that, given the proper care, probably would not be justified to be in prison. But that's a deeper issue that we're not going to be digging into. But it's important to note that because of this, the good of closing down mental asylums, the downside was a lot of individuals ended up in the prison system. So obviously, we've mentioned a couple times, but it kind of danced around it. Overcrowding. We know it because we hear it. It's always a buzzword when we talk about prisons and jails. We're always talking about the overcrowding. Number one, overcrowding is not supposed to happen. It's one of those, like, it's almost a violation of human rights, even if you're a prisoner. And so usually prisons are in trouble when they are overpopulated. They're supposed to work at a certain capacity, so they need to remove those individuals. So there is a whole issue with that, but some of the ways to actually do this and to avoid overcrowding, we've actually started making, at least here in Erie, and that's decriminalizing or reducing the classification of crimes so that fewer and fewer people are sent to prison. So decriminalizing marijuana means that anyone who is going to be caught with marijuana under a certain amount would just get a fine. They wouldn't be sent to prison, which they would have in the past, that kind of thing. So there are ways to go about this, but there's still, we can do better to avoid overcrowding. And hint, hint, maybe that might be a discussion board question that I ask, is about how do we combat overcrowding in prisons? Possibly, hint, hint. So the other thing that comes with prisons, before we talk about prisoner rights, because I think it's important that we do focus on this, I was actually going to make it a special topics until I remembered, oh wait, we actually talk about it, is prison programs. So prisons in general kind of act like a mini society, a little city within itself. And so they try to offer programs, and the programs that are offered through a prison really depend on jurisdiction, and that also means it depends on population, city, funding, all of these things. So some programs you might have heard of are work release programs, which we will talk about in a little bit, but the potential programs really depend on the individual prison, the individual jurisdiction itself. Since I do not work in our Erie prison system, I cannot tell you what our own programs are here at the Erie County Prison. I don't know. I'd be interested to know, but that's not necessarily public information. So can't help you there. But if you're interested and you do end up working in that system, feel free to let me know, because that would be really cool to, have that kind of come back and information share. Anyway, so let's, if I'm still in here, let's talk about prisoner rights. This tends to be a debated topic. People get passionate about this, and if you do, that's awesome. If you don't, that's awesome too. It's a gray area. If you remember way back early in this class, I mentioned that the criminal justice system is black and white in nature. It wants to be black and white, but the world itself is gray. Prisoners' rights is in that gray area. So despite the fact that they are an incarcerated individual, that they have broken the law in some way, shape, or form, the idea that they retain some of their rights is true. I know some people say, if you broke the law, you don't have any rights. That's not true. And if that is your own personal belief, I can understand it, but I argue that maybe in listening to this and us talking through it, maybe you'll change your view on it. I'm not hoping to change it, but I'm just hoping to put forward all the information for you to make an informed decision. So obviously, some of the rights that a prisoner has is the right to security and safety. If they are being incarcerated, they are promised some kind of security and safety. They don't go to prison thinking that they're going to get stabbed the moment they walk in. Now, if we take the traditional stereotypes of Hollywood, obviously, oh no, you're sending them, they're going to get killed. Yeah, there's violence, but there is a level of security and safety that is promised. It's a right that we all have. This would be something that we will talk about here in a little bit, but it's a fundamental right that you have. You have the right to have security and safety. Oddly enough, this is one that's interesting, and I've heard people fight on both sides for political rights. And I don't mean like they're allowed to run for politics. I mean, the right to vote is a political right. And despite the fact that people like to think that the blanket statement of, oh, you're a crime, you have no right to vote, that's actually not a federal law. It's actually a state decision. So some states can ban your right to vote for life. Some can make it temporarily. You can apply to have it reinstated. But removing the right to vote is not required by the federal government for an individual when they enter into the system. So, yeah, just a weird little fun fact for you about the right to vote, because we always love to talk about, oh, convicted felon, you can't vote. It's not necessarily true. Anyway, as a citizen of the United States, even if you broke a law, you still have a right to free speech and assembly, as well as the freedom of religion. There is an asterisk on it. There is a caveat. There is a slight variation. When you are within the prison system, the administration of that prison can ban certain activities that could potentially risk security. So, yes, you can assemble. Yes, you can choose to express your religion how you will, but if it is a clear risk to the security of the facility or the nearby community, your right is circumvented. It is not revoked, but it goes around it and says, yeah, you can't do that. Obviously, you have a right to the courts. In particular, you have the right to petition your an appeal of your sentence. So you're much like you're allowed to have a fair and speedy trial, you have the right to actually, appeal your sentence. All right. You also have the freedom from retaliation. I'm really struggling to say this one only because this is a fine line, and this is one that even in the corporate world, if you work at a job and you've ever been told, you can't be retaliated against if you are a whistleblower or if you put forward an issue and things like that. It's a wonderful idea. The idea is you can file complaints or grievances or even a lawsuit without any retaliation. But this is a hard thing, both in the business world and as a prisoner. Obviously, the staff at a prison can often find, and I put in air quotes, legitimate reasons to take action or to what we would say is retaliate against an individual. Same with a business. They can always try to find a, quote, legal, legit way to remove you from a job. It's a fine line. Technically, you're not supposed to. You're not allowed to be retaliated, but there's always a way around it. So that's why it's important to note something that you do not have is a right to privacy. This is one of the few that prisoners do not have the right for. When you are on their property, when you are in the prison system, They can search and seize anything as a shakedown at the discretion of the staff. It doesn't have to be probable cause or anything. You do not have that right to privacy anymore. That is one of those unfortunate pieces. In any kind of disciplinary proceedings, there are some rights that you have and some that you don't have as a prisoner. Prisoners are allowed advanced written notice. They're in fact supposed to get some kind of advanced written notice, written statement from the fact finders of evidence and the reasons for said action. So the jury typically or the judge. They are allowed to call witness and present evidence in their defense at a disciplinary proceeding, but they are not allowed to cross-examine any witnesses, and they are not allowed the right, or they don't have the right to retained or appointed counsel. So technically speaking, they don't have the necessary right at a disciplinary proceeding to have a lawyer. They should, and we'll talk about that in a little bit, but yeah. And the other thing that prisoners have as a right is the freedom from cruel and unusual punishment. And this really is, we've talked about it before, cruel and unusual is defined differently in the criminal justice system. This breaks down to things like unnecessary roughness or minimal measures of necessities. Essentially, you cannot take away a prisoner's right to eat or drink or sleep. That would be unreasonable, and thereby it would not be okay. So you have the basic rights of what is reasonable for a human being to survive. So yeah, there's that. So according to our textbook, and it's a little, I don't want to say dated because it's older data, but it's important to note that this is a real trend thing and why we're seeing more on the other aspect of this conversation. So we talked about prisons and jails. Now we're talking about community corrections. And so in particular, what we are looking at here is, and I'm going to even change the color of the text, we're looking at parole and probation. Okay, so let's see. I want to change this color to purple. Yeah, that works for me. Okay, parole and probation. So, according to our author and the text, community supervision, which is parole and probation, costs less than roughly $1,000 per person, whereas incarceration costs up to $30,000 per person. So, we know significantly that the cost to keep an individual in prison is fairly high. There's the ever classic number that people like to throw out when arguing for or against the death penalty, that the price to keep a prisoner alive on death row is quote unquote more expensive than it is to actually kill an individual. That data is outdated. Some of the more recent data will show you that it's actually the opposite. But the idea is that it is expensive to incarcerate an individual. And so there's a big push for rehabilitation again. We're trying to avoid keeping individuals in the system. So anyway, I'm asking this as a rhetorical question because, again, this is a recorded lecture, but what's the difference between parole and probation? Did you get it? Well, if not, here's the answer. If you did get it, congratulations. Let me know. And I don't know. I'd like to say I'll give you a sticker, but that sounds pretty childish. Okay. Parole, the idea is that it is an early release from prison where you will follow certain rules, and the idea is that it will lessen the financial burden on society. So we go from the 30,000 to 1,000. So obviously with parole, there are conditions of parole, and these do vary from jurisdiction to jurisdiction, but some of the main particular ones that are across the board are no intoxicants, no criminal associations, and regular reports to a parole officer. And so we'll talk about a little bit what having a parole officer is, but in probation, it's very similar to parole, which is why we tend to put them together. But the biggest difference is that parole is an early release from prison. Probation tends to be not in prison. Instead of being placed in the prison system to begin with, you are simply placed on probation. So, same kind of model. You have some conditions of probation. So, typically, also no intoxicants, no criminal associations. Regularly report to your probation officer. But yeah, you don't go to prison. That's one of the big differences. So, a parole officer and to an extent a probation officer, they serve a dual purpose. And the first one is obviously to prohibit dangerous behavior. So, you're not reoffending, and I don't mean you as in my students are going to become criminals. I mean that the individual is not committing any kind of crime. They're not engaging in behaviors that would cost them their parole or probation. And so the second part of having an officer is they also act as a guide or advisor, and they shape the individual. So if you want to be a parole or probation officer, please know, and I will say this again later, but the best parole and or probation officer is someone who sees both the criminal justice side and the social work side. And again, I'll talk about that in a little bit. So the whole point of the parole or probation officer is you are their guide. You are the person that watches over and keeps them accountable. So you guide them. So an officer actually can revoke parole if the parolee is unable to abide by the conditions of said parole. Obviously, they don't just, I revoke it and they take them to prison. Obviously, it goes through an actual system and a hearing, but we'll talk about that, I think, briefly here in a little bit. Yeah, I will talk about it here in a minute. But it's important to note that, the parole officer does have a role in revoking those rights. So like I said, probation is very similar. In the 1920s, probation officers moved to a more therapeutic model. And then in the 1960s, it went back to service brokers where, yeah, you were still therapeutic. You were still helping the individual cope and go through these things. But probation officers were also, trying to help find employment, housing, finances, helping them with their finances, like balancing and things like that, as well as finding education. So, as a probation officer, your job is to help. You're helping these individuals become progressive. That's not the right word. Productive members of society. That's the word I wanted. And so, in probation in particular, we do actually have two types of supervision. And why did I do that? Okay, so in both of these cases, but in particular in probation, there is active supervision and inactive supervision. Hopefully, it makes sense just based off the words, but if not, active supervision. I don't know where that word came from. Active supervision is where you are required to check in, or the parolee or probation, the individual on probation, that's the word I'm going with because I can't think of the actual word. That individual is required to report in at regular intervals with their probation officer. And inactive supervision is more of like random, infrequent check-ins and things of that nature. And now, obviously, as we've gotten better with technology and whatnot, these check-ins used to always be, house visits, in person, face to face. Nowadays, phone calls, video calls, things like that can be used as well. But again, that's a jurisdiction by jurisdiction decision. That's not necessarily a across the board thing. So the other thing that comes up in this section of the book that I just want to touch on is violators versus absconders. So a violator of parole or probation are people that just broke the rules. They violated their parole. They violated their probation. So they get in trouble and they can have their probation or parole revoked. But an absconder, ABSCONDER, an absconder is someone who has just refused to check in and has essentially disappeared. This is different than not abiding by the rules. This is you've gone missing and potentially run away. So, yeah, there is a distinction. I wanted to mention that. So, focusing in on being an officer, a parole officer, a probation officer, their role is to represent their client's best interest. You are meant to represent the incarcerated or recently no longer incarcerated or the never been incarcerated but now on probation individual. Your job is to work in the best interest of them as long as it doesn't constitute a threat to public safety. You should be wanting to help them, not, well, I want to get them back in prison. If prison is the right answer, then that's fine, but that's not the goal. So, obviously, when we talk about this kind of stuff with probation and parole, there are, certain things you have to do. We kind of talked a little bit about it where, you can't have intoxicants or criminal associations and regularly have to report to your officer and that kind of thing. But there are also intermediate sanctions, and we've talked a little bit about this before. We talked about one of them. Actually, we talked about two of them. But anyway, these are punishments that are less severe than prison, but are more severe than parole. So the idea is that these are not probationary things. These are more parole things. But yeah, well, let's just dive into it. So the one that we did talk about before is the intensive supervision probation. This is where high-risk reoffenders are monitored frequently by a small caseload officer. So this idea here is that the individual has more time to spend with the parolee, with the individual who needs this kind of close one-on-one work. So, like I said, we talked about it before, the ISP, the intensive supervision probation. So it's not like I'm bringing up a new concept, but I just wanted to emphasize, I said we'd talk about it probably later. It is like probation, but one step further. It is more severe, more closely monitored, more restrictive in a sense. Obviously, I mentioned it before in this video itself, but the work release program, this is where you live in a secured facility, but you're allowed to be released from said facility for work only. Yeah, it's your way of saying, yeah, I'm good enough to return to society to give back, but clearly I can't be trusted to live all on my own with no consequences. So that is an important kind of distinction. That's why I said it's less punishment than a prison, but more than just parole. And then the other one that we did talk about before is boot camps. So it's the military structure that, you have to do this, and hard work and rigid everything makes you a better person and less likely to re-offend. And of course, statistically shows that there's like little to no difference in recidivism rate. Just want to keep mentioning that anytime someone wants to be like, boot camps work. No, they don't. No, they don't. Statistically speaking, they don't. Look at that. This is a small notes page. I don't mean to say that as a bad thing, but as it is the last chapter of the book, there's a lot less to talk about. So anyway, the last part of the book, it is the last part of the book, but the last part of the chapter and last part of the book talks about parole and probation. In particular, how the law works in. So if you remember, we did spend some time talking about the law and what kind of laws are out there and things like that. So how does that play in? So we've kind of, things tend to be connected, and this is a system that is connected from beginning to end. So as we kind of said a little bit earlier, there are prisoner rights. So there are legal rights regarding parole and probation individuals, despite historically not, having rights as prisoners for a long time. So it is important to note that there are these rights. And so because of that, we need to talk about the legal side of it, the law aspect of it. And so we mentioned it briefly already, but I do want to dive into the actual thing. That's the revocation or revoking of parole. And so obviously, if a parolee, an individual who's on parole, fails to abide by the rules of their parole, they can have their parole revoked. And what this means is that typically they are sent back into prison. And the other part of this is not only are they sent back to prison, but their time spent on parole is not counted towards their total time. So they still have to serve their full sentence. But in regards to this, how this process kind of begins is there are two questions that are asked. The first one is, has the parolee violated their parole or probation, if we're talking about a probation individual? But if the answer is yes, they have violated their parole agreement, I don't know why I just all of a sudden lost my words, but if an individual, if a parolee has violated their parole or probation in any way, shape, or form, if the answer is yes, then the second question is asked. If it's no, then it's a null point and it is not part of the revocation of parole, and we wouldn't be talking about it. So obviously the answer is typically yes. The second question asks for more of the severity and other things. And so this is where we get into that social work side. So should the parolee return to prison or some other alternative steps be taken? So often in this revocation of parole, clearly parole is not working, at least not the way it is now. So the options are, do they go back into the prison system or do we approach this differently? And so this can show up as, maybe their issue, the reason they broke parole was they were doing illegal drugs. So maybe they need to go to a rehabilitation facility before they can continue their parole. So that would be a readjustment and that would be a change and that would be part of their initial parole being revoked. Maybe it is a matter of them needing harsher or stricter, rather, not harsher, stricter requirements and things of that nature. So, yeah, part of that is it's not just, oh, you go back to prison. No, sometimes it's what alternatives are there. All right. Another thing that is in relation to the law and parole and probation, and this is just the kind of interesting one, is the concept of due process. I don't know if in the earlier part of this chapter as we were talking, if you really kind of thought about it, but where does due process come in? Because it's kind of a constitutional right, but do prisoners have it? And so despite losing some liberties, individuals are allowed due process. However, they can also be informal when it is in regards to a parole or probation, a parolee or individual on probation. And there are some landmark cases, and I am just going to kind of quickly mark down these cases for you just so you have reference. And so forgive me, I am going to be typing and trying to talk, and that doesn't always work. So Morrissey versus Brewer, which was 1972. Hold on while I adjust this because I want it to be on each line themselves. Gagnon versus Scarpelli, which was 73. Sorry, sometimes I get sing-songy. And then Mempa, versus Ray. And that was 1967. All right. So, these are this is in regards to the due process for parole and probation individuals. So, technically speaking, we'll go in chronological order. So we'll talk about the Mempa versus Ray, 1967 first. But this was a case that entitled an individual to have counsel at all of their hearings. So if you remember earlier, I mentioned that, technically speaking, they weren't guaranteed the right to counsel at their stuff. So Mempa versus Ray, 1967, said that even though they're not part of the quote-unquote legal justice system, they still have an impact on their freedom and liberty. So they are allowed the right to have their counsel at all hearings. And so that's why I said we'll come back to it. I didn't want to dive too much into it because I wanted to talk about that. Morrissey versus Brewer, this is where the conversation of the Supreme Court was that they will not make a blanket decision on how procedures should work in regards to revocation hearings for parole, but they also did list some minimal requirements. And so that's actually something I want to look at real quickly because it's kind of cool to look at. I believe it's under this section. Let's pretend. Yes, it is under this section. Okay, so 1972, Supreme Court refused to write a code of procedure for parole revocation hearings. They said it's the responsibility of each state. In the case, the court pointed out that most states have procedures already in place, and they established a list of the minimum due process requirements that must be followed. So they looked at what the states were doing, and they said that at the bare minimum, in the case of any parole revocation hearings, you have to include a written notice of the claimed violations of parole, a disclosure of the parolee to the parolee of evidence against them, opportunity to be heard in person and to present witness and documentary evidence, the right to confront and cross-examine adverse witnesses unless the hearing officer specifically finds good cause for not allowing for confrontation, neutral and detached hearing body such as a traditional parole board, members of which need not be judicial officers or lawyers, and a written statement by the fact finders as to the evidence relied on and reasons for revoking parole. I feel like I said these things before, so it must be they're important. Hint, hint, nudge, nudge. We repeat things because they are rights and they are important. So I did want to emphasize that, while they didn't give a clear this is what you have to do or this is how it needs to be worked, these are you have to have the bare minimum things. And then Gagnon versus Scarpelli a year later pretty much built on this, and considering that the minimum standards also included from Morrissey and Brewer was that you had 2 hearings in regards to parole, this doubled down on that. And so parole and probation were also a problem because in the Gagnon versus Scarpelli issue, it was a probation, not a parole thing. So the argument was, statistically speaking, and looking at just the data, parole and probation are very similar in design, and they deserve the same rights despite not being a parole. So that's why, we have the parole/probation, why we talk about these together, because they are very similar. Obviously, they're greatly different because one spent time in prison previously and the other one has not spent time in prison. But for all intents and purposes, they follow the same basic rules. And so Gagnon versus Scarpelli was the case that said, yes, if you are probation, you have the same rights as a parolee in regards to the process of a revocation hearing as well as just due process in general. All right. So the Fourth Amendment, which is the search and seizure piece, each state, this is another one that's not at the federal level. This is each state decides how much of the Fourth Amendment a parolee must relinquish. So some states, you will sign a waiver and essentially waive all Fourth Amendment rights, but in others, not necessarily the case. So much like, being able to vote, it's up to the state. So in some states, an officer can technically search your property at any time. In others, it can be the probation officer only, and it can be based only on probable cause. So like there are plenty of limiters, but it all depends on the individual jurisdiction. We've talked about it before. We keep coming back to it. Jurisdiction, jurisdiction, jurisdiction. That tends to be the big piece. So with this idea of prisoner rights and how the law factors into all this, there is one other thing that I want to talk about. And I promise this is actually the last thing to talk about this week and in this lecture. And that is, and I'm going to change the color, conditions. I'm even going to make it red because it's important. So conditions are just if you don't know what a condition is, it's a particular rule or factor or concept that must be followed. So any kind of parole or probation has to fall under certain conditions. And we've definitely talked about some of these before because, hint, hint, they're important. So I'm just going to write down some of them real quickly, and then we'll talk about them in a second. Okay. So, when we talk about conditions, if you remember when we talked about law, clarity is important. If a reasonable person, or in this case, a reasonable parolee, cannot determine what is prohibited, obviously you cannot make it a condition of their parole. So you can't say, the parolee must live a just and virtuous life. What the heck does just and virtuous mean? That is way too vague. You need to clarify it. So that's the, important piece of clarity, is that it has to be easily understood. Obviously, reasonable is the counterpart to avoiding cruel and unusual punishment. So when we say reasonable, we mean realistic. This must be whatever the condition of the parole or the probation is, it must be attainable by the parolee. So if they're a person that doesn't make a lot of money at their job, part of their probation can't be $10,000 a month in restitution charges. If they don't make enough money to pay for that, then clearly they're going to violate their probation or parole and have to go to prison. That's not fair. That's not reasonable. That's not realistic. So this clarity and reasonableness, these are the two big ones that any probation or parole must meet. It also needs to be constitutional. And in particular, when I say constitutional, we're talking about fundamental rights. And there's a reason why we emphasize that. So the idea is that your conditions of parole cannot, or probation cannot infringe on the constitutional rights that are not impacted by being incarcerated. And these are often seen as the fundamental rights of an individual. These are the freedom of press, freedom of assembly, freedom of speech, freedom of religion. These are the big ones that, tend to be hard to argue against. A good example is you can't force a parolee to attend Sunday school every Sunday. That goes against the freedom of religion. So, yeah, that can't be part of your conditions of parole or probation. Now, obviously, you can make a condition that you cannot assemble at a bar for an individual. That would be a fair and reasonable condition that's not against a fundamental right. But preventing an individual from meeting anyone and forcing them to be confined to a house with no visitors, that could be a violation of a fundamental right, the right to assembly. So hopefully that makes sense with why I said, like, it's kind of a weird line. Constitutionality is big. We've talked about it several times before. Remember, the Constitution and the Bill of Rights, this is the big piece for what is and is not allowed in the criminal justice system. And then the last one I want to talk about is protection/rehabilitation. So this is supposed to be the goal of parole and probation. The goal is to rehabilitate the individual and protect both them and the community at large. So because this is the goal, any conditions have to meet either one or both. This is also used to avoid other cruel and unusual punishments that are seen as, scarlet letter punishments, things meant to make you feel bad and guilty. So this idea that your conditions of parole or probation have to be, clear, realistic, not infringe on your rights, and have a goal that you will be a rehabilitated individual, then it's all good. If not, well, then we have an issue. All right. So thank you very much. I know that this lecture was I haven't edited anything yet because this is all live when I talk. So I don't know how long this actual lecture is going to be. I imagine it's probably going to be a shorter one. But thank you for listening. This is the last chapter. There was a lot of information, but a lot of it was repeating stuff we've already talked about. So this is really, I wanted to give you the new information, and we touched on some of the old stuff. Let me know if you have any questions. If you, want to know more about a particular subject, please send me an email. Let me know, because next week, week 8, is our final week. You will have to turn in your essay at the beginning of the week, and you will also have to complete the final. But outside of that, we'll talk about special topics. Like I said, I will talk about juvenile justice, but if there's another topic you're interested in, please let me know. Hopefully you read the chapter and you listened to this lecture and these notes as a supplemental piece to build upon what was talked about in the chapter. Thank you very much, and I'll talk to you all soon when we talk about our next special topics. All right, bye for now.